So it's quite actually interesting today. Paul Moon's just currently at the moment writing a book. He's a New Zealand academic, and he's quietly writing a book at the moment about um, basically the Declaration of 1834-35, the He Whakapuna, which my pronunciation is not perfect, guys. Don't take it personally. I murder languages bilingually. And it's interesting because one of the things he's basically saying is it didn't get really very far because it really wasn't really accepted by the Crown, and it really didn't get any official recognition. Which I'm not saying that Paul's wrong because he's actually still writing the book and searching any stuff out before it gets to print. But when I was looking at it, like I had this image in my mind of one of the pop artists of our area. I think it's a guy that does the four square with a pencil behind his back, and he kind of turns it from Mickey Mouse into Mario's Fazil, Dick Fazil. So Dick Fazil does a painting of basically signing the Declaration of the Treaty of Waitangi in 1840, which he also then that's a take off another famous painting, and it's got all the signs of flags. And somewhere in my mind, I cross-referred over and went, "Oh, I said, Paul, wasn't there like 10 other ships present in the bay?" Making a point that there was wasn't more like actually wasn't there foreign recognition of this, and also wasn't there actually that it wasn't just set, it was signed, like the paperwork was actually sent to New South Wales, was put into the Admiral Gazettes, the Admiralty recognised the flag of 1835, and the interesting reading about this is that in some ways I'm right about things, in other parts I'm wrong about it. The wrong is it wasn't 10 ships in the harbour, it was 3 American ships which are not actually listed. But you had, I want to say Cleedon, I think it's Cleedon, he was a British representative in 1835, and he, however, did a lot of work, business with the Americans, and came to become New Zealand's first US consulate, and he was very much aware of the 1835, and this is actually the first letter, declaration credentials, when he's introducing his credentials, actually says he's recognising it to the United Chiefs. So we have, and there's another thing out there called the Littlewood Treaty. I think that's 1838, give or take. I might be again check those dates on that one, but the point is we actually do have formal paperwork basically where the American government is recognising the 1835 treaty. There's also a Baron Charles von Hugel. I originally thought he was German. He's actually Austrian. No formal credentials, but he was direct access to the Emperor in Austria, and was widely treated as a VIP by both the New Zealand representation and the New South Wales government. Both again, so he again was aware of this particular issue. In 1840, when 1835 gets low down and then the British put up the Union Jack, which causes a bit of immediate problems with both Maoris, but it's also recognised by Cleedon, and he's at the time also accompanied by a Captain Wilkes, who's from part of an American ship, who's on an Antarctic expedition, and he's got a group of scientists, and he actually goes out and talks to chiefs and says, "Well, what do you think about this? Doesn't this fly in the case of?" He makes direct reference to the Declaration of 1835, and he's sort of saying, well, wait a minute, he's also sort of saying, well, wait a minute, well, actually, the reason why you're raising the flag in the first place is the treaty is, and not just treating this as an act of discovery, as we've turned down this country doesn't belong to the government, we're just taking it. Is they'd actually already done 1835, and they actually had to legally then turn around and actually carry this actually out. So the next aspect of it also is that Paul said, "Oh, what about this? Mention it. That's like mention." So what saying, he was saying one of the reasons why I didn't off the ground was it didn't really get much representation or acknowledgement from the Crown back home in England. But I was like, well, yes and no, because in the Admiralty were recognising it, and yes, again, I was able to go and find reference sources, basically again citing the fact that this was actually raised and mentioned. The thing it's interesting also, I mean, and basically what you've got here is a really compelling argument, in the very opposite of Hobson's pledge, is that you've got a very compelling argument that the government, that the Maori chiefs of New Zealand thought that they actually were being recognised, that they weren't succeeding sovereignty, and the point is from a constitutional viewpoint of well, not all the chiefs actually recognise it, blah blah blah. It doesn't matter. The point is the Crown itself had already turned around and signed with for I think it was about 30 chiefs. It's each, and again we'll get to that point too because it's very important. It wasn't just signed with chiefs. it was signed with a large representation of the United Chiefs of the North, and which meant that the English had acknowledged the fact that actually they'd not made this treaty, they'd recognised that there was this bit of land over here and that people lived here and that they had a right to their own self-determination. And so that, I think, is very important in terms of laying the foundation of where we go from, here and now. People keep trying to steer us towards this point of republic, and that's, to me, is an extension of what we're going, is that we've signed this treaty in 1835. We've then jacked up the 1840 with two different varieties, and again, the version that the Americans had was actually the original version. It's in the Maori, so it's actually, we have an actual on record now of which came first, which has always been disputed. So you have your Treaty of Principles, but we actually have say, well, actually no, this actually over here. We've got the original right over here. But then, we move forward, and we've moved forward to the 1986 Constitutional Act, and then we've moved forward to the 2004 Supreme Court Acts, and both these have been done without a House or majority, a full House majority. They've only been done with a party majority, which actually is in breach of the 1953 Act, which deals with basically constitutional issues, and that's why we had a referendum, John Key's referendum, which again, I find it very interesting that the idea was that, well, it's just time for change. Don't worry about that. It's got nothing important. And as a political scientist, I went, well, no, that's not how it works. And flags are actually important. And again, John Key himself acknowledges that the flag debate was a referendum because it was a constitutional issue. And again, my thing that I made at the time, which was I turned around and said, well, actually, taking the flag away is kind of like John Key and his mates, TPPA mates, kind of like trying to pull the wool over everyone's face and say, New Zealand's not a democracy based in Westminster, things like Magna Carta and the British English statutes. No, we'll just forget about that, and we'll just let you forget about that, and we'll move off in this direction towards republicanism. Where the definition of human rights mean two different completely things, because one draws its power base from Westminster Parliament in England, which is not the same, which is again part of the mischief. They keep trying to get people think that the Union Jack is Buckingham Palace. It's not. It's about parliamentary democracy, and it's holding everybody is being held accordingly to the law with an equal, whether you're a king or a peasant, the law applies to you, and that's where you gain your Magna Carta comes up in reference. But again, in New Zealand, it's quite often widely misquoted by people, misunderstood, because they think that all of Magna Carta applies, when in actual fact it's only Article 29, which again, when I've raised this issue and I've tried to put me on TV story to the tune of X-Files, what I wrote, and have newspaper articles, and they've misquoted me, and they're trying to make me say I'm talking about all of Magna Carta and I'm a sovereign citizen, when I'm actually only talking about Article 29, and those same newspaper articles are not mentioning that I'm a political scientist, a qualified academic, I have a degree in political science, or mentioning my history in this particular issue, when they talk about these stories and trying to make it out like it's a conspiracy theories. I think it was Paul Goldsmith, when actually the Attorney General for on the Treaty or Waitangi Principles, and he described what I was saying as moderately nuts. And again, to be fair to him, he was having explained to him by journalists who actually hadn't explained to that particular politician who I was, or the full context, so they misrepresented, and of course they got a quote. And I think they also did that to Professor Geddes, who turned around and said, there's no such thing as due authority, and that was the one that was done to the tune of the X-Files, except for Story later pulled that piece because they had lawyers keep on going, well, actually there are. And then I talked to Paul about this actually when I knocked on his door when I was doing a thing for OAR FM, which and actually I ended up losing my show as a result of this, and because I went and I said, I'm from OAR, I'm from OAR FM, which was in their mind, so I was misrepresenting myself. I was doing it for a show on OAR FM, so in my mind I was quite legitimate. But the point was, and the tape went zhunk. But the point was, I said to Paul at the time, I said, well, okay, what's this, the due authority? He said, oh no, well actually it does exist, but he's misquoted it. Again, because he was being presented, how it was being presented to the media, it wasn't that I had got it wrong, it was how the information was being presented. So it was, it was a very dirty journalism what they did there. But yes, the short version was that by the parliamentary website also had said at the time when this was all going on, and just to show you the level of the trickery and deceit here, and why we really need to be kind of understand that this is not randomly happening, this has been quite orchestrated, was that original Parliament in New Zealand used to say the Union Jack is on the flag to represent us of our democratic tradition. So it wasn't about the Crown, it was there to represent the fact that we were a Westminster system democracy. Now, anyone again wants to dispute that, I suggest you jump on a plane and go and visit the memorial in Canberra, where one of the copies of the Magna Carta is actually on display there in relation to, or directly in relation to Union Jack, which again is when English or Australian residents actually petitioned the Crown and said, well, actually, we're sick and tired of being basically treated like slaves by the oligarch Australian squatters. We would like actually the British law to be applied, and they petitioned it. And then you got the, I think it was the New South Wales Constitution Act or the Australian Constitution Act, which actually includes New Zealand in 1902, which is, I think, a year after we actually got our flag, but they're both directly related to each other. And again, all these Commonwealth countries have this Union Jack. Again, this issue gets brought up again at the time after, when this, this TV put out this, due authority, that's all a conspiracy theory, completely misunderstanding and actually letting people believe that the due authority is not even a real word, that it was a made-up word, which it's not. Black's Law, if you want a source reference. So the other parliaments, so they removed that from the website, which is our democratic traditions. Again, you can see in Australia that actually comes from the same area. And then after the TPA debate, which was happening at the same time that John Key was putting through, and trying again come up with a treaty that created sovereign or all the powers from overseas to have more power than our own existing courts, which directly runs in breach of our Bill of Rights 1688, the third clause, which deals with what is often known as the papacy clause, but it actually deals with that fact that any foreign power, ecclesiastic, military, or whatever, cannot actually be represented above the courts of the law. And that's in clause 3 of the Bill of Rights, which is part of the statutes, which are said as a constitutional issue under 1953 Act. Instead, again, 1986, in terms of the fact that was passed through incorrectly, you can go and look at Justice Cook, because he brings that point up. He calls it a legal fiction. And I think one of Andrew Giddy's students, I think Donna something or other, just look it up, and it'll reference in terms of the Supreme Court Act and Otago University, and it'll come up. It's one of his Giddy's students, and she also turned around and said, actually, yes, the Supreme Court Act wasn't passed properly, but it seems to work. And I think that's an incredibly amazing statement to be put in an academic, at a PhD level. Oh, yeah, don't worry, we broke the rules, but that's okay, it seems to work. Because that actually is the problem. We just keep piling up, deviating from due process and getting ourselves into a worse and worse situation and not having an honest answer. And this is really good about what Paul Moon's doing in terms of basically, he's writing a book which really underscores the importance of the 1834. I have one but to this, and the but is that the constantly is this continuation of trying to tie it into the idea of Rangatira ruled by the chiefs, and there's this idea which is I think it's also a very dangerous idea, and it's actually privatisation, provides the opportunity for privatisation for the back door, which is trying to apply this reference, like it did in Fiji with the Takaro movement, that only one group of people, class, actually have this rangatira, or they alone have a say in the concept of co-governance, and that's the reference in terms of 1834 is that there's a move to try and move it in terms of that saying 1834 reinforces the power of the chiefs. I dispute that, because if you look at 1834, it actually directly references the hapu and the significance of that. And also the fact that you could even say the fact that it was only done with the northern chiefs and not all of the chiefs. The point is, what it's trying to demonstrate by the mentioning hapu is that New Zealand at that time, when the colonials arrived into this treaty, wasn't like Europe with a single king sitting on the throne. Actually, ultimately what it was closer more to the Inuit or the Sioux Confederacy. So you've got a group of tribes, chiefs, sub-tribes, family members all come together and they form, and they all have an equal representation. So the basic theme is the power runs through the people, not in a triangle up to the pyramid, which is what the current model is. They're trying to rewrite the whakapapa, and they're trying to say, oh no, these high chiefs, they are the important ones, and all the rest, nobody else actually gets a say. And that again fits in with this TPA model, which is very similar again to what Governor Grey was doing, because he was trying to create this myth of the noble savage, to go and create this hierarchy, so that the Crown only had to deal with a few people, that cost them a few $1 million, bribe them, and then they could turn around and take the land off everybody else. I'm saying, no, actually, the recognition of the power of the sovereignty of New Zealand in 1834 was the power went through the people, and that's where we want to come from. We want to come from co-governance. We want to make sure we need to understand there's a difference between hapu and rangatira. And this point is again raised by Miriam Broughton, who wrote a very good paper about the importance of hapu and whānau recognisation in terms of power sharing, and said there's no. And when you look at the declaration, the constitutional conversation, which was think 2010 was at least was begun, and it might have been a couple of years later after that. But Dr. Peter Sharples and John Key organised this situation. So we're going to have this constitutional discussion, which is the beginnings of recognition of co-governance. And it's very, very sneaky because, as Marama Brown points out, it doesn't represent hapu or whānau, only the chiefs are recognised, which again fits this whole corporate model of you have a corporate-styled iwi board where only the people at the top get to make decisions and everyone else just does what they're told. And they're all driving around in Range Rovers and big houses, and we end up with a situation what we see in Tonga and Fiji. We have this the opposite of what we want in New Zealand. We have a massive shift between haves and have-nots, and we don't want that. We need to understand where we're going to have co-governance, which I think is something we should really be looking forward to. And there's nothing wrong with tearing down the flag or going to Republican as long as we understand what the checks and balances are. And so far we're having a discussion. We're not having a discussion about what the checks and balances are. We're just saying, we're going to do this and then we'll make it up afterwards, which is again what we did with the 1986 Constitutional Act, which was completely wrong, and it allowed Parliament to empower itself, which again goes against the Bill of Rights 1688, which says Parliament and the kings cannot empower themselves. They have to follow due process, which has been my entire point, is that due process keeps on getting deviated away, and therefore the due authority of these, where this power, the legitimacy of this power come from, there actually isn't any, because they have just railroaded things through. And this really, if I was, my niece is Maori, I'm not. I'm actually I'm a rarity, and I'm a 7th generation New Zealand without enough Maori blood in me to constitute being a Maori. But from a Maori viewpoint, and from New Zealand viewpoint, that's First Nation people. I would be very, very, very upset by this. The other thing about that conversation, that 2010 constitutional panel discussion, two things about it. Well, three things actually, about it. Number one, it didn't only just not mention whānau and hapu, it didn't make any reference to the English statutes, which is the Magna Carta and Article 29 of the Magna Carta and the Bill of Rights 1688, which I keep referring back through, which are our founding constitutional documents which give us our civil rights. And it means that we're not like these international treaties which actually get the authority that's signed under the New York Convention, which is New York was once a Dutch colony, so its definition of human rights is completely radically different from what it is for under the Westminster system. Westminster system recognises the inalienable rights, in other words, you have rights that you've got yourself and they can never be taken away from you. And the New York says, well, actually, you've got the rights and the captain can give it and take away it. Also very important is about that Magna Carta is, even though the letter of the law has changed and there's been massive change in Magna Carta, only Article 29 is only one of the few parts that has never changed, is it recognises the spirit of the law. Then it's not just good enough to give people rights, but the law rights must also contain them to good governance. So they're not just that the captain has full rights, the captain's got to do his job properly, and that's a major big difference between Westminster and that's not even mentioned in a constitutional discussion, which is largely made up of only one or two iwi, and they're both again Tānui and Ngātahu, which I'm not, I have good and bad things to say about both of those iwi, but the key thing in this particular case is that they are, they're recognising in this constitutional conversation, they're sending people that aren't even academics to discuss something that's really, really important, and they're leaving out the most biggest building blocks, both from a Pākehā viewpoint and both from a Maori viewpoint. So that's annoying. Another thing, of course, is that when you looked actually at the story about the New Zealand flag and you know the history and you take it back to Dame Jenny Shipley and the involvement of Saatchi, the way the entire referendum for the flag was run was completely sketchy. It was run by people who 10 years earlier been caught saying to the New Zealand government, if we get the $27 million tourism account, we'll give them a free promotion for their run at the next election. And it nearly cost Dame Jenny Shipley her job, and they buried it. And they trademarked things like the silver fern. I think it was either Nicky Bell from, I think it was Saatchi and Saatchi, but also Ed Drury from Xeros was in there, and it's actually his designer that came up with the peak point of light, which again references to the Havelock North, which is that's another very, very interesting story, but we'll save that one for another day. And then so you've got that, this point of peak of light, and then which brings into things like Don McLean and the very, very sketchy relationship he had used his role as Minister of Maori Affairs to actually steal land for himself. And then the other versions were all like Fern, which I said, this had been copyrighted. And there's all sorts of, that's another story itself, but like they had actually set this up so that there was going to be enrichment if we'd picked these choices of Fern, and they asked us, would you like to actually, which one of these ones would you like first? And then they asked us, should we have a change? I mean, that was completely back to front, and it was being run by these people who've been caught doing something very, very illogical and unethical beforehand. And again, unfortunately, that never came out during the flag debate because, as said, there was huge amounts of money. I think, in fact, the flag debate was $27 million, exact same amount that such and such had discussed with National back in 1991. So, that doesn't bode well. And of course, there was also the cross-reference that lots of the people that were sitting on the flag panel were also sitting in the constitutional discussion panel at $600 a day with no public consultation about why they should be picked for those positions. The government picked the yes people to do it. These are all the things that we need to be having. We need to be having a very, very serious discussion basically about what are going to be the checks and balances for any changes forward to make sure that our rights for everybody are protected. And that also that it's done in a transparent way, that it's not actually breaching, it's not deviating from due process. And this is the problem, we do not have these discussions in a calm manner anymore, and unfortunately governments have very complicated things and they can't be moved forward in a great hurry, and anybody trying to get you to do things in a hurry, be very, very wary of them. I just want to kind of get the last point I want to make through is that, to me, looking at what Paul Moon's been writing, it really reaffirms to me that yes, 1835 was actually a very important founding document for this country. And it also, for me, as I said, it's also important because it recognises the Hapu, which I've explained what that says about the power dynamics with New Zealand. And I think those things is that 1835, in conjunction with the Treaty of Waitangi, in terms of the spirit of how the Treaty of Waitangi was meant to be, the spirit of the law versus the letter of the law, which is, again, a big, huge, complicated argument. And finally, the English statutes, where we are in terms of what they are now, is that they have worked as a triangle, which basically means that we don't have a written constitution in New Zealand, but we have these constitutional mechanics which are very fluid, and they move in a triangle, they're lockstep and they protect each other. So there's things like fast tracking, there's things like special economic zones, and there's things like the TPPA. Good luck, however, I say to people who once you really understand what the beauty of our three-way protection is, this defence in depth, I say good luck to these people on the TPA from trying to actually get rid of the stuff, because as long as we're aware of it, it provides us such an incredibly amazing level of protection. And I guess the final thing I want to say is that what I kind of tried to mention beforehand was that about this whole issue about trying to pull off the Union Jack as a symbolic act, very key, not saying literally means this, but trying to say, actually, we're not a Westminster democracy, was all these things that I actually said when the Canadian Indians, when the TPA got to be signed and when they went forward to do TPPA, it was actually the Inuits of Canada that stopped this from happening, and they did it because they said, well, actually, you're obliged under the Commonwealth, the obligations to actually consult us, and these things actually fly in the breach of basically, Commonwealth law. So basically, most of what I was saying in terms of saying, well, actually, you can't be signing treaties that actually breach the very constitutional framework of Westminster by having them have a power that's spaced somewhere in New York and not actually your own country. That's pretty much what the Inuits came to, and they had to then turn around and they come up with CPTPP, Comprehensive Program Tests. They make the language so long that you don't even can't remember it. But the point is, that still includes these very dangerous investment state settlement dispute clauses, which again the Labor under the Jacinda Ardern neoliberalism regime, and again there's some people out there seem to think that she's a progressive, and I absolutely dispute that. But she went off and signed the TPA, and then later on turned around and said, "Oh no, we got rid of the ISD. TPPA became CPTPP because of the Inuits," and she said, "Oh no, it doesn't have the ISSD," which is another typical Ardern lie. All she says, the other thing she'd say was, I'll get back and I'll come back to you on that, and she never does. But Jane Kelsey, who's Professor Jane Kelsey, who really is, I recognise, one of the most authorities on the TPA, turns around and says, well, actually, no, that's not correct. It's still there. The only thing is it's in a dormant state, so it's there, and they're just hoping that no one pays attention until they've got all the other things set up, and then they can whack it. But if they try and do it now, then it wouldn't. It's only dangerous if it goes to the Supreme Court. and you've got 41 judges that are all married into each, or related by blood or by marriage to each other, and they might be tempted to go along with it because there's no checks and balance. Because again, otherwise, what would normally happen would they be going to the Privy Council? But the Privy Council has been mothballed, not shut down, mothballed, because again they couldn't shut it down, using this law which they didn't actually do it properly. And they now appoint all these political people, ex-politicians, including Helen Clark, who supported the TPA, and Winston Peters said he's against globalism, but when got into government, also supported the TPA. And again, I'm not quite sure how you can be on the Privy Council and be a serving minister, because that's a conflict of interest as well, which, in Westminster, the judiciary, the executive, the legislation should be actually separate from each other, and yet here we have Winston Peters wearing both hats, and nobody in our national media, fourth estate, is going, wait a minute, what's going on here? And that's what we're up against, but the information is there, and once it's exposed, it stops him from these foreign corporate globals from coming in. And at this stages, they've got they've run a publicity campaign very aimed towards Tanui, and Ngātahu and Tanui, such as things like Operation, what do they call it? Wahine Tora, Powerful Woman. And that's US Embassy, which is they basically went out and started inviting very prominent Maori women of those particular tribes to places, to America for nice junkets, and basically warming up anybody that had a checkbook so that they would be in line with the American fight, And so again, it's the soft diplomacy, but it's no different from Governor Gray saying, well, actually, we'll just bribe a few people and give them silk pants and tummy tucks, and they can, once we bribe those, and the rest of them will go along with them ripping our country off. And that's what we need to really get back for us. These are the points that all iwi, whānau, hapu need to be discussing throughout the country about how this is actually going on, and making sure that one or two tribes who doing it for their own purposes. And again, I understand the politics. I'm not good or bad, but it's just human nature. But they need to be, people. The more we know about this, the more this conversation is discussed at the hui, at the marae, and at huis, the more it strengthens and empowers us to make sure that we actually don't let this actually happen. And again, the Treaty of Waitangi is a partnership. It's between the Pākehā Tana Te Whenua, those born on the land, and who are guaranteed the protections of the Westminster law, and saying that also our Maori partners will actually have this, and vice versa. The Maori system is actually recognising that actually this is we're not completely some colonial, pasala colony answerable directly to the Crown. We actually are our own people, and we have our own sovereignty. And as I said, the He Whakapuna 1834 make sure that actually that this is not just a situation of having a few people at the top of the marae making all calls and we just swap one aristocracy for another. It's saying, actually, no, we are a nation of we the people. Anyway, those are my thoughts on this particular bit of journey I've just been going down recently, and I just thought I'd actually share that with you.